Hi, I'm Greg Dell with the law firm of Attorneys Dell Schaefer, and I'm here with attorney Stephen Jessup.
Greg.
And today we want to talk about probably the 5 most important reasons to have a disability attorney assist you with your appeal. Now, Steve, you've probably handled 500 ERISA disability appeals?
I'd have to say it's been quite a few.
Okay. What would be your #1 reason why someone should have an attorney to assist them with the filing of a ERISA long-term disability appeal?
Well, the most important and the overwhelming, need for an attorney or assistance in any way, shape, or form on the appeal is the fact that the appeal is your last chance to state your case, make your argument, supply the administrative record with information that's going to support disability in the event you end up in litigation. Some people, or when they go about doing the appeal, they're seeing that as the end of the road, the appeal. But realistically, the appeal is just a step for possibly potential litigation. So that appeal is, at that point, the most important document that you're going to, put into the claim. So it's always important to be able to make sure you're doing as much as you can to present that and preserve any legal arguments you have later on.
If a person calls you to handle their disability denial and you didn't handle their appeal for them and they did their appeal on their own, is it easier for you to handle the case, or is it more difficult for you to take a case after the appeal's already been done?
After the appeal's already been done and for litigation, it definitely makes it more of a challenge for litigation, because you live and die by what's in the claim file. For instance, if it's a complaint that's physical in nature, back problems, person says, listen, I can't lift anything, I can't do anything, and certain testing or examinations that could have been done to document that weren't done in the process of appealing it. Now it's hard to be able to give that objective evidence to kind of point to work towards this idea to the judge that the insurance company wasn't acting reasonable in denying the claim. Okay. So it does make it more challenging.
So let me just stop you there. If a claimant calls you and you review their file and all of their appeals are exhausted, and you look at the record and all of their information and say, oh, I would like for you to go for this test, can you get that information in to their case once the lawsuit's filed?
No, at that point, no. As soon as that last administrative denial comes down, you're done. Unfortunately, if someone was, to get in a car accident requires surgery, unfortunately, that's outside the scope of what's going to be able to be argued at litigation. So anything that happens after that final denial, it's as if it never happened almost. When it comes to trial. So
is it fair to say the day the disability insurance company makes their final denial of an appeal that no additional information can be added?
Essentially nothing, for all intents and purposes.
Okay. What is the most difficult thing for you in putting together an ERISA appeal for a claimant?
I think the hardest and most difficult thing to really capture in an appeal is the fact that knowing that if it's going to go to trial, there's going to be no live testimony. It's really humanizing the claimant, a matter of being able to tell a story or have what's really going on be portrayed as accurately and as completely as possible. Because at the end of the day, when faced with litigation, it's a stack of papers. So you got to make that stack of papers, those medical records, the job history, everything, you have to make it tell the story of the person. So I think that's probably the hardest thing, is really trying to impress upon what's really happening and the struggles that the person's faced.
I think, and I don't know if I think in a lot of ways it's an unfair system, because without an attorney, you're making a claimant basically go up against an insurance company and a claims handler who's trained to look for all kinds of inconsistencies and reasons why they're not able to prove their disability, and you're making the claimant become an attorney who's supposed to present everything when they don't even know what the weaknesses are that the insurance company would be looking for as a basis to deny the claim.
And realistically, I think anyone who's been to our website watching these videos already realize how unfair a system it really is, and that's unfortunate. The quote nature of the beast.
I think one of the other more difficult things about these ERISA appeals is the fact that the insurance companies get the benefit of the doubt, and that's like talking non-legal. Basically, that if their claim's denied, that the court's basically going to look at it under ERISA and say, insurance company had discretion to review the claim, and if we think they acted reasonably, then we can't overturn the denial, even if the judge disagrees with their decision. Mm-hmm. And I think that as an attorney, how do you take that into consideration and take some kind of strategy as to how much information you put into an appeal versus what you don't put into an appeal?
Well, it's always that's the, I think, the art of the appeal with respect to putting in the evidence that needs to be there. You don't necessarily want to tip your hat because the insurance company does have an advantage. You don't want to tip your hat as to certain factors that you know might be available to you to get past this idea of reasonableness when it comes to trial. So there's a fine line between, trying to make whether it be legal argument or, inflammatory statements even, and just really trying to be as exacting about getting the information, the medical information that's going to support and those factors, and then saving what you have for trial, because they do their final review. You don't get a chance to respond to that, so they get the last word.
You brought up a great term. You said the art of the appeal, and we get cases all the time where another person did their own appeal or another law firm did the appeal, and then they hire us for litigation. And all too often, our hands almost get tied because we see people who submit appeals and they basically tell the insurance company exactly what they didn't do and what they need to do. And while a layman, a person who's not experienced in this area of the law, may think that's the right thing to do, but if you do that and you don't win the appeal, I think you have very little chance of success, once a lawsuit's filed.
Yeah, because if the insurance company goes and they remedy what they did wrong, it's a no harm, no foul situation. So that's very, very true.
And then, we could talk about probably 50 more things that are difficult about ERISA appeals and why you need an attorney, but what do you do in the situation where you submit an appeal and now the insurance company wants to do another independent medical exam, or they're going to do another file review of the person's medical records? How do you respond to that?
With respect to that, and usually in addressing and submitting the filing of the appeal, there's a request that any additional type of report that may be doctored or examination, I always try my best, and sometimes that's going to require even trying to either allow an extension or the extension taking place, so you can at least try to get that report to your client's treating physician so they can at least comment on it, so you do have a chance to try to at least respond to what they're going to do.
And then another thing we've been seeing a lot, but from your experience, how often do the insurance companies respond within the 45 days that they have once the appeal is submitted?
More often than not, it seems that on the 45th day you get the notice that they'll be taking the extension beyond. I'd have to say that the majority of the cases, it's always they're looking for that extension, whether it's just because they're inundated with work or whatever the case may be. It seems like that you get a letter of acknowledgement that they received the appeal, and then the next time you hear from them, even requesting updates, it's for the request for the 45-day extension because they're waiting on some review or some of this or whatever the story may be.
And then why does the insurance company give a claimant 180 days to do an appeal, and is it important to take 180 days to do an appeal?
It's important in the sense that you have to get as much information as you can in 180 days. I know we've discussed this. When you have no income coming in, that's a long time for anyone. But when you take a look at the bigger picture, 180 days or 6 months with respect to maybe benefits that are going to last 10, 15, 20 years, 180 days isn't a long time. And if that's your last crack, that's your last at bat, you want to, if you need to take that time, you take that time to make sure that you're getting as much as you can to strengthen the claim.
But I think that it also takes a lot of time because sometimes it takes just 30 days to get the claim file. It can take another 30, 45 days to get medical records from the claimant's own treating doctor.
Or to get them in for the testing that they may need to supplement the file.
Right, so there's and getting a letter of recommendation or a letter of reference from a coworker or a friend or a family member. So it all takes time. The problem is how's a claimant supposed to survive financially during this period of time when they've already been denied? Now there's the appeal, and then it's going to take another 45 or 90 days for the insurance company to respond. What's a claimant supposed to do?
That's a million-dollar question. I mean, essentially, it's the insurance company starving people into submission. And you will see where people will go back to work. They just have had enough. They try to go back to work and do it, and the insurance company gets an easy out of sorts. Right,
and I think the insurance companies, one of their techniques are let's deny, and then let's try to strong-arm the claimant into going back to work because we know they can't afford themselves. And I know you do and I do. I always try to tell claimants, look, we'll work on your appeal as quick as possible. We know time is of the essence, but we got to get all the evidence in, and if you really truly can't do your work, you can't go back, because if you do try to go back and if you do get fired or terminated, then you could lose all your benefits altogether. So you got to really try to hang in there and reach out to anybody that you have to try to help you, because if you have a good claim, you're going to win most of the time. So thank you for joining me today to discuss ERISA appeals and why it's important to have an attorney. As you know, and most of our viewers know already, we always offer a free consultation regarding an ERISA denial or even application or any stage of your claim. So feel free to call us at your convenience, and we would be happy to discuss your disability claim with you.